Assalamualaikum and hi everyone. My name is Nur Izzati binti Muhammad Rizal, metric number I181028812, and my friend Siti Mazlin binti Muhammad Rizal, metric number I181028887. Today we will talk about chapter 7, legal issue. So let's go. The subtopic for this chapter is first, law affecting performance management. Legal and ethical issue in performance management, employment law, and the last one is how to avoid legal trouble in conducting performance management. Okay, we move to 7.1, law affecting performance management. In the past few decades, several countries have passed laws prohibiting discrimination based on race, ethnic, national religion, sex, religion, age, disability status, and sexual orientation. As you guys can see, there are 9 laws affecting performance, which is first is Equal Pay Act of 1907. The aim of this law is to give individuals the right to the same contractual pay and benefit as a person of opposite sex in the same employment. Next is Race Relations Act of 1976. This is to make it illegal to discriminate against someone on the ground of color, race, nationality, or ethnic or national origins. Next is Sex Discrimination Act of 1975. It's made it illegal to discriminate on the grounds of sex, material status, and gender registrants in a limited manner. Next is Disability Discrimination Act of 1995. It made it illegal to discriminate on the ground of disability status. Next is Employment Equality Sexual Orientation Regulation 2003. This law is to make it illegal to discriminate on the ground of sexual orientation. Next is Employment Equality Religion or Belief Regulation 2003. It's to make it illegal to discriminate on the ground of religion and belief. Next is Equal Pay Act of 1963. Prohibits sex discrimination in the payment of wages. Next is Civil Rights Act of 1964 as amended by the Equal Employment Opportunity Act of 1972. This is prohibit discrimination on the basis of race, color, religion, sex, or national origin. And the last one is Age Discrimination in Employment Act of 1967. Prohibit discrimination on the basis of age. Okay, we move to 7.2, legal and ethical issue in performance management. There are 6 important principles often come into play in the case of litigation related to the implementation of a performance management system. First is employment at will, negligence, defamation, misrepresentations, adverse impact, and illegal discriminations. Employment at will, the employer or employee can end the employment relationship at any time. This type of employment relationship gives employers considerable latitude in determining whether, when, and how to measure and reward performance. An employer could potentially end the employment relationship without documenting any performance problem. There are two acceptations regarding an organization's ability to terminate an employee under these circumstances. There may be an implied contract derives from conversation with others in the organization or from information found in the company documentation. For example, employee handbook, indicating that employees would be terminated for cause only. And the second one is decision about terminating an employee should consider a potential violation of public policy. Next is negligence. Many organizations outline a performance management system in their employee manual, employment contract, or other document. When the system is described in such document and not implemented as described, legal problems arise. For example, there be a description of how frequently appraisal take place or how frequently supervisor and employees are to meet formally to discuss performance issue. If an employee receive what she believes in an unfair performance evaluating and the system has not been implemented as was expected, she may be able to challenge the system based on negligence on the part of the organization. Is defamation. Defamation is the disclosure or unfavorable performance information that damage an employee's reputation. An employee can argue that the organization defamed her if the employer states false and libelous information during the course of the performance evaluating or negligently or intentionally communication this statement to the third party, such as a potential future employer, thus subjecting the employee to harm or lose the reputations. But we must understand that defamation doesn't exist when information regarding poor performance is clearly documented. Next is misrepresentation. Whereas defamation is about disclosing untrue or unfavorable information, but misrepresentation is about disclosing untrue favorable performance, and this information causes risk or harm to others. When a past employer provides a glowing recommendation for a former employee who was actually terminated because of poor performance, that employer is guilty of misrepresentations. Next is adverse impact. Adverse impact, also called unintentional discrimination, occur when the performance management system has an unintentional impact on a protected class such as sex or race. So if a group of white men consistently receive lower performance score, then there is adverse impact because those individuals share the same characteristic, male, or a class that is a protector that is sex. Last one is illegal discrimination. Illegal discrimination, also called disparate treatment, means that rates assign score differently to various employees based on factors that are not performance related, such as race, nationality, color, or ethnic and national origin. As a consequence of such as ratings, some employees receive more training, feedback or reward than others. Illegal discrimination is usually referred to as disparate treatment because employees claim they were intentionally treated differently because of their sex, race, ethnicity, national origin, age, disability status, or other status protected under the law. The majority of legal cases involving performance management system involve a claim of disparate treatment. What can an employee do if, for example, she feels she was giving unfairly low performance score and skipped over for promotion because she is a woman? To make such a claim, an employee can present direct evidence of discrimination, such as a supervisor making sexist comments that may have influenced the performance management process. Alternatively, she needs to provide evidence regarding the following issue. First is, she is a member of protected class. She suffered an adverse employment decision as a result of a performance evaluation, was skipped over for promotion. She should not have been skipped over for promotion because her performance level deserved the promotion. The promotion was not given to anyone, or it was given to an employee who is not a member of the same protected class, that is another woman. If an employee provides this kind of evidence, the employer must articulate a legitimate and non-discriminatory reason for not having given the promotion to this female employee. Usually, this involves a reason that is clearly performance related. So that's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Siti Mazlim binti Muhammad Rijal and my matric number I181028887. Okay, today I would like to explain about the employment law. What is employment law? Okay, employment law is that individual employees and employer are free to form employment contract, but this contract must comply with the relevant employment legislation. Okay, employment law is relevant to business as many people are either employer or employees. So the areas of law relevant include contract of employment, termination of employee with or without notice, wages, provision regarding annual leave, holidays, hours of work, industrial action, and the collective right of the employees. Okay, now the Employment Act is the law relating to the relationship between the employer and the employee are derived from a variety of sources. Okay, the main source is the legislation, the Employment Act. The main objective of employment laws is that the employees should get a fair wages, amenities, and at the same time protection from against exploitation. Other characteristics of the Employment Act are that they provide the contract of service, notice to be given of termination of a contract of service, rules regarding the payment of wages, provision for termination, layoff benefits, the given of right to employee to make a complaint, and etc. Okay, now in employment law must have the Employment Provident Fund and the Employee Social Security Act, the Occupational Safety and Health, and then trade unions and the Industrial Relations Act. Okay, and first I will explain about the Employees Provident Fund Act. It established a system of a compulsory saving, so the employees will have money to support themselves once they are retired. So the Act cover all the employees and administered by the Employees Provident Fund Board. The second one is the Employee Social Security Act. So the administered by the Social Security, as known as SOCSO, ensure the employee will receive a compensation in case of a work-related accident or illness. If something happen when we doing employee doing the jobs, so SOCSO can be claimed or cover us from the accidents and the illness regarding to the job lah. And then the Occupational Safety and Health Act 2 is establish guideline and the laydowns the responsibility of the various parties in the industry in relation to safety and health. Okay, every employer shall establish a safety and health committee at the place of the work if there are 40 or more person employer at the place work. So the community should keep under review the measure taken to ensure the safety and health of a person at the place work and should investigate any matter at the workplace which a member of the community of a person employed treated considered is not safe or risk to the health. And then the Trade Unions Act is the seeks to control the activities of the trade unions so they can develop in an orderly and peaceful manner. And this is done by laying down rules and regulations which unions are required to follow. Okay, the last one is the Industrial Relations Act. Regulates the relation between employers and workmen and their unions, as well as laying down rules to help prevent and settle disputes between the two parties, thus ensuring peaceful industrial relationship as far as possible. Okay, the Employment Act 1955 deals with the contract of the employment, but it is not applicable for every employee or every employer. It's only applicable to those employer and employee who fall within the definition of the Act. Okay. The first schedule to the Act defines employee as those who earn wages not more than 1,500 per month, and any person who has entered into a contract of service with the employer without regard to his wages. Okay, is engaged as a manual labor, supervises employees engaged in the manual labor, engaged in the operation, maintenance of any vehicle for the transport of passenger or goods. Okay, for the public sector employees consisting of a civil. Okay, for the public sector employees consisting of the civil services, statutory bodies and the local authority to have expanded from the Act. In most cases, they enjoy a better benefits. The benefit provided include the termination and the maternity benefits, the right to a weekly rest day, annual leave, and sick leave. Okay, to decide whether employee is protected by the Act or not, wages is defined as a basic wages, excluding annual bonus, overtime payment, commission, and traveling allowance. Okay, next we will go to the employee rights. Okay, the number one is wages. According to the section 2 of the Employment Act, wages mean the basic wages or the other payment in cash payable to an employee for work done in respect of the contract of service, but does not include annual bonus, overtime payment, commission, and traveling allowance. Okay, number 2 is working hours and leave. Exploitative employers have been known as required employees to work a very long hours without a break in order to ensure maximization of the profit, while short-term gain may be achieved in this way, the health of the employees will suffer and eventually the quality of work also will be affected. According to the section 60A of the Employment Act, normally an employee cannot be asked to work for more than 8 until 10 hours in a day and more than 48 hours in 1 week. An employee may be required to exceed the above limit of hours and to work on rest day in the following circumstances, according like to accidents, urgent work to be done to machinery or plant, or an interruption of work which is impossible to foresee. Okay, the third one is a rest day. There are some research evidence to suggest that the accidents are more likely to occur at night or late in the day when the workers are tired and sleepy. The Employment Act therefore required all the employees protected by the Act to permitted 1 rest day per week. Lately, however, there has been a growing trend for companies to introduce a 2 days weekend break. Okay, number 4 is the annual leave. Employees are only entitled to annual leave once they are complete years of the service. However, some employers will permit their workers some annual leave even in the first year of the service. Okay, the duration to annual leave granted to the workers depend on their length of service with their employer as provided by the section 60E clause 1 of the Act. Workers with below 2 years service entitled 8 days per year. Workers with the 2 until 5 years will entitle 12 days per year, and the workers more than 5 years seniority have the right to 16 days of the annual leave per year. Okay, the last one is the sick leave. Employees are also entitled for sick leave. Before they can avail themselves in this privilege, they must undergo an examination by a registered medical practitioner appointed by the employer, as known as the panel doctor, and be certified by the doctor to be unfit for the work as the provided by section 60 clause F of the Act. Okay, an employee's sick leave entitlement, like his annual leave, depend on his length of service as provided by the same section. Like 2 years below can get entitled 14 days sick leave per year. Workers with 2 until 5 years services entitled 18 days sick leave per year. And then 5 years seniority have the right to the 22 days per year. Okay, when the hospitalization is required, the employee is entitled to up to 60-day paid medical leave per year, inclusive of any sick leave entitlement. Okay, the next one is the employee rights. Number 1 is the termination and notice. Lawful termination take place by giving appropriate notice, section 12 of the Act. Either party to the contract of service may at any time give to the other parties notice of his intention to terminate such a contract of the service. Okay, the termination must be with a proper reason and following the procedure. If the termination is improperly made, the employee may make claim of the reinstatement. The length of the notice should be same for both employers and employees. The period of the notice to be determined by making a provision in writing in the terms of the contract service. Whereas the contract is a silent, the provision of the Employment Act will apply. Okay, section 12 of the Act states that where the contract is silent on the length of the notice period, Then the notice should not be less than 4 weeks notice if the employee have been employed for the last 2 years, and 6 week notice if he has been employed for 2 years and more but less than 5 years. Okay, 8 weeks notice if has been employed for the 5 years or more. Nevertheless, according to Section 13 of the Act, either the employer or employee can terminate a contract of service without giving the required notice if he pays the other party an indemnity, like a sum of money equivalent to the amount of the wages which would have been earned during the notice of the period. Okay, the second one is the termination for a misconduct. An employee may be dismissed on the ground of the misconduct without any notice after due to inquiry or downgraded of imposed lesser punishment under the Section 14 Clause 1 of the Act. Misconduct are not defined in the Employment Act, but it may include the absence from work without notice or excuse, sexual harassment of the co-workers, breach and implied duties of loyalty and confidence, for example, leaking a company secret and breaching the confidentially, and then gambling while at work, sleeping while on the job, example, as a job security, and a poor performance of work which does not commensurate with their experience claimed in the resume. Okay, the next one is the last one is the how to avoid legal trouble in conducting performance management. The first one is don't harass or discriminate. It should go without saying, but any sign of bias, stereotyping, or outright slurs in an evaluation inappropriate and can lead to the serious legal trouble. Sometimes bias creeps into an evaluation through the application of stereotypes, criticizing a female employee's assertiveness or an older employee's lack of energy and inability to master new technology, for example, will sound like a prejudice to a judge or jury. And the second one is document everything. Carefully document employee performance throughout the years. Will also have the evidence you need to rely on your evaluation in the court if it comes to that. Okay, if you later have to rely on the performance assessment to demonstrate why you disciplined or fired an employee, contemporaneous documentation will be your best legal friend. Your log or appraisal written at the time the problem surfaced will help your company prove that the problem were real and the employee knew about them, and your company didn't manufacture them after the fact to try to cover up an illegal termination. Okay, the last one is don't retaliate. When an employee complains about discrimination, harassment, or another violation of a workplace law, or if the employee supports another employee complaint, you must be especially careful if you take any action that the employee might view as a punishment for making the complaint, including giving the employee a negative performance evaluation because of the complaint. You might find yourself in the wrong ends of a lawsuit. It's illegal to retaliate against an employee for complaining about the discrimination or another violation of a workplace law to you, someone else in your company, or a government agency. This doesn't mean you can give an employee in this situation a negative evaluation if the employee job performance warrants it. It does mean, however, you should to be prepared to back up your negative evaluation with documents and evidence supporting your assessment. Okay, the last one is a conclusion. Okay, as a conclusion, employment law is the area of the law that governs the employee-employee relationship. Therefore, if the business has more than one employee, then the business likely use the employment law. Considerable protecting the right of the employee can be seen from various changes and the transformation that have been introduced to the employment laws, as an employee need to understand and alert with the contract that been made. Okay, that's all from me. Thank you.